his cases against Twitter, YouTube, / Google, and Facebook have a similar flaw in the lawyers being employed. He has the right idea. Credit to him for pursuing it in the court of public opinion, pursue it in the court of law to elevate the attention to the issue. Credit to him for wanting to do so on a class action basis. He has the right purpose, right idea, very poor execution because of who the lawyers are. And I have serious doubts about what their motivation really is.
Now, I did a video breaking down the Twitter one. I didn't see the Facebook, Google, but I assume it's effectively the same sort of allegations where we're invoking the state actor argument that they were heeding to pressure from Democrat politicians and therefore basically acting under their instruction and therefore can be deemed to be state actors who are therefore subject to the constitutional requirements not to censor free speech based on viewpoint discrimination. So unless I'm mistaken on that, I'll just do the summary of the Twitter case, which is basically going after Twitter and Dorsey personally, arguing that they are constitutionally bound because they have become state actors, because a bunch of Democrat politicians said, we don't think Trump should have a Twitter account. He shouldn't be tweeting like this. We're going to revoke Section 230 immunity if you keep allowing this type of speech on your platform. Twitter bans Trump and a bunch of other class members, proposed class members, at the direction of Jack Dorsey. Therefore, they become state actors. Jack Dorsey's become personally responsible, despite, the corporate veil. And that's the essence of the lawsuit. One thing that I noticed is that they seem to be sucking and blowing in that they were saying basically they become state actors, but the law was unconstitutional because it immunized them from censorship, which they would have otherwise been entitled to if they were private actors. So, I guess, look, ultimately, assessment of the lawsuit itself, and then we're going to get into the discussion about the lawyers because that's totally foreign to me. What's your take on the lawsuit, chances of success, and any strengths or all the weaknesses?
They've managed to bring the weakest possible claim and forego the strongest possible claims. That's why I wondered, once I dug into who the lawyers were, whether this was a deliberate poison pill to kill the cases. Because, for example, Trump's clear right idea to go after big tech. He's the president of the United States, or he was the president of the United States, and he's the most egregious example of censorship that's ever occurred and its most problematic consequences. What he could have brought was a combination of claims. If he was going to bring the claim, the best claim on the state actor side is not a class action claim. He doesn't even meet the standards for class actions. It's that, hey, I was the president of the United States, and I was still removed. And in order to meet that, given that, Bobby Kennedy's suit which was much stronger factually, was dismissed by the district court, because essentially what the courts are saying right now is that in order, and if they had even consulted any of the lawyers involved in this space, Harmeet Dillon, Ron Coleman, Harmeet Dillon has by far the strongest state actor suit against social media pending in California because she waited to get the receipts first and made direct proof. This is something they could have done too. Trump's people could have done FOIA requests, got the intel first before they brought the suit. But the only way you're going to be able to get the state actor, given what happened in the Bobby Kennedy suit, now he's appealing that and we'll see what the law is, but is to say specifically, and in my view, Trump easily could have. They have inferential evidence. They don't have direct evidence, but that's what discovery is for.
And now, this, I don't know how it works, but could they have alleged the type of conduct that was already included in the California lawsuit, which was exponentially stronger as far as state compulsion of a private actor than anything they alleged in the Twitter suit? Can you incorporate by reference other lawsuits wherein that evidence has yet to be made in a court of law?
All you have to do for a direct allegation is, most cases when you make an accusation against somebody, you don't have the proof of it yet. You have reasons to believe that discovery will show it. So you say upon information and belief, and you lay out and here they had strong inferential evidence from the FOIA information that had already been disclosed, from the suit that came from the Harmeet Dillon suit, from the Bobby Kennedy suits. All of that had enough background information that what you need to allege right now, to allege state actor, Trump had the best state actor claim out there. This is why I'm concerned about why they deliberately chose to sabotage it. What Trump needed to say was simply Vice President Kamala Harris, Speaker of the House Nancy Pelosi, CDC Director Fauci instructed Zach Dorsey, Mark Zuckerberg, I won't even try to pronunciate the Google's name, YouTube, instructed each of them to remove the president of the United States accounts from being available to communicate to the people. And that's it. Then you have a clear, clean state actor, both as to them as individuals, because that's no longer a corporate veil issue. You're not saying they're responsible because of what their company did. You're saying they individually chose to impose that upon their company because a state actor told them to do so. Now, does he have direct proof of that yet? No. But does he have plenty of indirect proof? Absolutely. And that would get him to discovery, which I guarantee would be very revelatory. Instead, they went out of their way not to allege that. Instead, they alleged a claim that their own court cases they talk about make it clear to be where this suit is going right now. It's likely to get transferred to California. Number one. Number two, it will be dismissed. It will likely be dismissed on anti-SLAPP grounds because that's enforceable in federal court. And Trump is going to end up paying Twitter, Facebook, Google, YouTube, and Zuckerberg and Dorsey and the other dudes attorney's fees. That's where this is going. And it almost seems deliberate because of, like I said, there was what he could have claimed that would have been very strong. And there's what he did claim, which was which their own court cases say you can't bring. To give folks an idea out there, the one thing that does not constitute a state actor is a private actor being motivated by the idea that a state actor will be happy with their actions and give them some form of relief or remedy. That is, their own court cases make that clear. And yet that's their entire theory. They chose to abandon the direct allegation that's necessary to get there and bring the theory they know is going to get dismissed.
And again, and not only that now, and again, I don't know. Look, I know what I don't know about American law, but I know the questions I ask when they say some federal entities benefited from Twitter's conduct. And I'm thinking that's, correct if I'm wrong, totally irrelevant that they may have indirect.
And there's existing case law on this. And they even cite some of those cases. That's why I was like, they're telling the judge, they're giving the clerk a roadmap. So, by the way, here's how frivolous our case is. That made me wonder. I was like, who in the world? I was stunned because I was like, there's nobody that's in this field that is on this lawsuit. No First Amendment lawyers, no big constitutional lawyers, no big anti-big tech lawyers. And then I started asking around. None of them had even been consulted. And I was like, well, what's going on here? And then I read the suit, see how it's poison pilled, because there are a bunch of other claims he could have brought. The class action claim to have brought was to bring a claim challenging the Pruneyard doctrines in federal law, because in California, this also would have discouraged them from trying to move it to California and reduce the attorney's fees risk for Trump. Because in California, the Pruneyard doctrine still applies. And what that says is when a private company is exercising a traditional public duty, such as owning and operating the public square. This goes back to Marsh v. Alabama that the Supreme Court then pulled back on. But you could, on good faith grounds, say, you know what, we should go back to Marsh, adopt California's Pruneyard doctrine, which says a private mall can be obligated. Because the Pruneyard's argument was, hey, this violates our First Amendment rights because we're being forced to allow people whose opinions we disagree with distribute material in our mall. It's exactly what big tech argued in getting the Florida big tech law struck down. And the U.S. Supreme Court said, no, that doesn't violate your rights. That's within the state of California's constitutional prerogative to choose to protect the public square part of a private mall as a superior First Amendment right to the mall's expression, which is not really impacted. So my argument was, hey, we now have a digital, just because the public square is now digital rather than physical, now in the online world rather than a specific geographic space, doesn't mean we should change our First Amendment standards. And there's a bunch of case law where the Supreme Court calls the digital public square that. And so come back in and say on a class, that's your class action claim. And you say, and you know you're maybe challenging existing law, but then you set it up for the best argument for the court of public opinion for your future policy argument. You scare off the defendants from trying to even take it to California because their Pruneyard doctrine applies. If they do take it there, you bring a California state claim and make California state part of the class action. That's your second claim. And then you bring other common law claims. I thought for sure Trump would bring a claim that says, all these people got rich off of me. The reality is monetizing me over the last 4 years made them millions, likely maybe even billions of dollars.
It would, I'm not mistaken, it would be a claim for unjust enrichment where they did undoubtedly gain millions of followers, hundreds of millions in ad revenue from Trump's presence being on these platforms. And then once they no longer need the golden goose, I don't want to say the analogy because people think it's a threat, but once they no longer need him, dispatch of him. And I don't know why people have not made this argument yet. Knowing that Glenn Greenwald's YouTube channel has been fully demonetized from what I understand. I want people to look out.
Alison Morrow was suspended for simply pointing out what NBC was doing.
No,
she just repeated what NBC was doing, and they said, "Oh, you can't talk about what NBC is doing." I mean, because they don't like what NBC. Well, supposedly, I mean that gives an idea. She was suspended for a week. By the way, her wine promo is good. That's legitimate wine, folks. That's top-notch wine.
So for everybody who doesn't know, this will be a small parenthesis. Alison Morrow was suspended for a week for a video talking about mainstream media where she was penalized for repeating what was reported on the mainstream on these mainstream media sites, much like Gad Sad getting kicked off of Facebook for sharing someone else's comment because of hateful content. She was restored. Her suspension was reversed. But Glenn Greenwald.
Oh, was it? I thought it was still in force.
No, apparently she posted a video today. I was listening to her live on Locals.
Yeah, that would be the court of public, because they originally denied her appeal with that Orwellian language that says that we did this for your own benefit, and we might have done it for this reason, and if not, it was this other reason. If not, it might have been this other reason. You realize you're getting a pure AI screw over. Well, that's great she got reinstated. That's only because the court of public opinion putting pressure on YouTube on social media.
Well, that's one explanation, whether or not it's just someone looked at it a second time. But I think, yes, they get enough pressure, they get enough tweets. Team YouTube, in as much as they're bots, there are still humans there, and they go back and look it over. But no, someone like Glenn Greenwald or someone who gets their channel entirely demonetized, if I ever see an ad on that giving YouTube's new terms of service, there's a claim for unjust enrichment, if not outright deceitful business practices. So,
for Trump had the ultimate unjust enrichment claim. I mean, no individual in the world has had a strong unjust enrichment claim as Trump. And it would highlight the issue. It would play in great politically. It would be like, these guys made billions of dollars off of me, and then they tried to silence me because they wanted to go a different political route. Well, but I want my billions of dollars back. And he also could have alleged consumer fraud as well under the Florida statutes. So, and that makes it harder to remove to California. And now, so instead,
so he's filed the suit, but he's not precluded from filing a suit alleging these claims. He can still bring
all those claims. It's just, as long as these lawyers are involved, it's obvious those claims won't be brought. This claim is made to look like it was when it happens that he ends up having to pay the other side's legal fees, loses. It's made to make state actor claims look bad, make Trump's claims look bad. And it's not a surprise if you dig in. It's one of these fake America First groups. It's called it's America First Policy Initiative or something like that. You dig in, it's all big oil money. They're all corporate lobbyists. A lot of them are Wall Street connected. There are a lot of Jared Kushner's pals. So these are people that he's probably going to block me now on Twitter. But that's who a lot of these people. It's like we probably got uninvited from Joe Rogan, uninvited from Tim Pool, and now I got Jared Kushner on me. But hey, say love you.
And I just want to. There's nothing. We say nothing here. I say nothing in the hopes of appealing to someone bigger for what that's not how I've ever been brought up. It's not how I've ever conducted myself. And I'm not shy about these things. And I like that Robert speaks the truth as he sees it. But Robert, one thing, again, I'm not a US lawyer. I know what is required for class action law here. I didn't realize it was a class action until I saw it in the header, but until the end where they define the group. There were, as far as I understand, they didn't allege all of the other things that need to be alleged, the practicality of the group, the ability of the law firm to handle a class action, the appropriateness of the selected representative. Typically, you have not pages, but you have 4 or 5 criteria that need to be alleged in order to justify the class action. Here, they just threw in the definition of the class and then ended the lawsuit. And I thought that was not right.
Oh, yeah, no, there's no chance of the class ever being certified. So for people that think this is a current class action, it's not. It's not a class action until the federal judge certifies it as a class action. That will never occur. It'll get dismissed before that ever happens. So that's why it's just, it's not helpful. It's hurtful to Trump's causes and claims. And the part they brought that's a class action make no sense, because what they're really saying is Trump was specifically targeted by state actors using big tech. That's not a class. That's only Trump. There aren't a million other Trumps. No, but the class action part would have been unjust enrichment, some part of that, of consumer fraud, some part of that. But the big one would have been the public treating this as a public square, a digital public square under the Marsh Doctrine and under the Pruneyard Doctrine, and arguing for a change in existing law to extend that to the modern space. And by the way, I thought they would follow Thomas's guide. They ignored every point that Thomas raised. They don't bring a single point up that Thomas talked about.
Yeah,
not the public utility argument. Thomas doesn't like this precise state actor argument. That's not his thing. He likes other claims. They ignored all of them. And it's because the 3 or 4 of the lawyers work in a Virginia real estate law firm where what they do is help you get your title transferred. What are they doing being the main drafters of such a case? Then another lawyer is a local insurance lawyer, probably just the local pro-op counsel for Florida. And the only guy with a name who appeared is Greta Van Sustren's husband, who the last time he did something interesting, it was the 1980s. So, I mean, it's like this is a disaster of a list of lawyers. The reason why Dershowitz is out there talking about how important it is I assume Dershowitz, he understands policy-wise how important it is, this whole issue of big tech censorship. But it's because Dershowitz is trying to get a hold of Trump, because this is how you get a hold of Trump. You go on Fox News, unfortunately. But because Dershowitz knows it needs to be improved.
Yeah, and I saw Dershowitz's comments. It's a big question. It's just it's not the right way to go about it by lawsuit. And people are
the wrong suit. It's just the wrong. Trump has the best claims of anybody. They've just brought, and I think his motivations are completely correct in this. He just has these corrupt corporate lawyers. This was always his problem. Either corrupt insiders or crazy outsiders. And it was back and forth, back and forth. And there's a third option of strategically smart outsiders. There's a bunch of us out there. It doesn't have to, I mean, it not only me, obviously, but there's Harmeet Dillon, there's Ron Coleman, there's Alan Dershowitz, there's the people who are helping out Bobby Kennedy. There's a bunch of other people that are trying to be on the front lines on these cases that really understand this. So a lot of us have been talking about this, how to go at big tech, for 5 years. I brought one of the first suits against Twitter in California for Charles Johnson, and got a decent settlement out of it because they recognize their risk on appeal. Now, the problem is you have to sue in California, and if you lose, you have to pay the other side's legal fees. People ask me why I haven't brought more suits. That's why. The client's like, I'm not willing to take that risk given the politics of the court right now. But Trump is in the best possible position, and he brought the weakest possible claim. You dig in, these are Rick Perry's people. These are, big government, big corporate lobbyists their whole lives. These are people who are good on issues like school choice and regulation and taxation, things like that. They have no business in this space. And like I said, once I saw they cited the very cases in the lawsuit that make it clear to the clerk and the judge the case is basically frivolous, that made me wonder what was the real motivation of some of these people involved.
And it's look, arguing motivation can never be proven nor disproven, but there's a question of judgment here. We saw the outline.
It's either extreme legal malpractice or overt corruption. That's my.
We saw what Clarence Thomas laid out in his dissenting refusal of certiorari, and I forget the case. He laid out the groundwork, the idea, the public utilities argument, the new public
unconstitutionality argument to say that state laws can't be limited because that makes it unconstitutional under state prerogatives. He laid out how you could go at big tech under other grounds, whether Section 230 really means what they claim it means. So he laid out a roadmap of where it could be challenged constitutionally and statutorily, and they don't bring any of those claims. Instead, they bring a claim that their own suit admits, if you understand what it's saying. It's a suit that Trump, who doesn't understand law, would think is a good suit because they include all those tweets and comments. But what it doesn't, and it praises Trump a lot.
Yeah, well, that's what I was going to say. And it alleges that he has a masterful use of social media, which everyone loves.
It was designed to make Trump think it's a good suit when it's actually not. That's why I have serious doubts about their motivation. Then when I saw who this was, I was like, these are the same corrupt actors that misdirected the White House for 4 years.
People are asking, how do you get this message to Trump? I mean, look at
just as many people that reach out to him as possible. That's about it. I mean, Trump is Trump. God bless his soul. But you have to scream a lot, and maybe he hears you, maybe he doesn't.